SJC-13168, Commonwealth v. Eric Moreau.
Okay, Attorney Grant.
Good morning. May it please the court, Anne Grant for Eric Moreau. Your Honors, the question in this case is whether police, in investigating an OUI, can obtain a search warrant to test a defendant's blood for blood alcohol content, BAC, without his consent after it has been drawn by a hospital for medical purposes. Your Honors, I would submit this is a simple statutory construction case. The OUI statute grants protection that exceeds those granted by the Constitution or the Declaration of Rights, because we know it's not unconstitutional to get a warrant for blood test or to do a blood test in exigent circumstances. But the plain language of the statute requires the defendant's consent before police direct a blood test for analysis.
Well, counsel, can I ask? Oh, go ahead, Justice Gaziano.
You're probably going to ask the same question. Doesn't the statute say at the direction of the police?
It does, yes.
Okay. So the norm, what you've seen, I'm sure in practice, is there's a motor vehicle accident. The police have nothing to do with it. That's litigated. Then they go and they get a search warrant, or they go and they get the records from the hospital. You have that hearing you always have about whether or not it was at their direction, the police. And they say, no, it was for medical treatment. The person had a head injury. How is this different?
Well, in this scenario, we're talking about the hospital drawing the blood, but the police obtaining the blood and then testing it.
Okay,
yes.
At the direction of the police. How is this at the direction of the police?
For them to test the blood
for them to draw the blood. They didn't do it.
I'm not arguing that they directed the blood draw. I'm not arguing that. I'm arguing that they directed the testing of the blood for BAC.
And that would have been where I wanted to focus for a minute, counsel, is that it says test or analysis. Is that correct?
Yes.
So the analysis, the actual testing and the analysis of when the police ordered the blood and received the blood, they tested it in their own lab, right?
Yes, that's right. They tested or analyzed the blood. Both of those words refer to the.
Is it accurate that the hospital didn't do a blood test? They did a blood test, but they did not analyze the blood for alcohol?
I can't be of assistance as to what the hospital did. What I can answer is that in this case, the hospital drew the blood and the police then obtained that blood via search warrant and then tested it themselves for BAC. And what I've submit to your honor that the statute explicitly says is that a test or analysis will only be admissible provided it was made with the consent of the defendant when it was, by or at the direction of police, which it clearly was here since the police tested or analyzed it in the state police crime lab. And that for that reason, it's explicitly controlled by the statute in that they did this test or analysis themselves, and therefore failing to get his consent makes that.
If I could ask you, just putting aside that Bohemian's all about the blood draw. When you look at the statute as a whole, and you look at the defendant's right to be able to have an independent medical exam originally, and that this is also tied to the language with the breathalyzer, isn't it clear not to obtain an absurd result inconsistent with the statute that we're talking about when the police are doing a blood or a breathalyzer, not whether or not a week and a half later, when, as Justice Gaziano said, the blood from the hospital gets into a crime lab, that what do the police do? Call and ask, can we test your blood? And if not, revoke their license for 180 days. The whole thrust of the statute is for the defendant's consent at the time they're going to take the breathalyzer or the time that blood is going to be drawn, isn't it?
Your Honor, respectfully, I disagree. I don't think there is a temporal requirement listed in the statute. In Bohegan, Your Honor, I believe that this court found that the consent provision included a blood draw in saying that because a blood draw is a necessary prerequisite to a blood test, and there are public policy reasons why we don't want unconsented to blood draws directed by police, that the consent provision must also cover blood draws. But what the consent provision explicitly says is tests or analysis by police. And it doesn't say that if they do it a week later in their crime lab, that that's somehow okay. I would submit that in the scenario that you're talking about, if, say Mr. Moreau had been told by police, the hospital took your blood, we would like to test it. We want your consent to test it. And if he refused, then if he had been subject to 24(1)(f)(1), then he would have been subject to the license loss. In this case, he was actually not under arrest, so he was subject to 24(1)(e). But that, I don't think, leads to an absurd result. The legislature had multiple purposes in enacting the statute. Clearly, an overriding concern was public safety, but it also granted these specific rights to defendants. And the rights were ratcheted up or sort of more strong depending on the serious, pardon me, the inverse of what I'm trying to say. The less serious the charge, the more strong the right. So for example, in 24(1)(e), where the person is not under arrest, that category of defendants can refuse the blood test and not be subject to a license loss. But if they're in 24(1)(f)(1) and they are under arrest, they are subject to a license loss according to the statute. And that continues to ratchet up depending on the seriousness of the category that they fall into. So I would submit that under that statutory scheme, it's clear that the legislature had multiple purposes, and that an additional purpose that's obvious here is privacy concerns. I'm sorry, Justice Wentlet, are you trying to interrupt me? I don't want to speak over to you.
I am, thank you very much. So let's just say that literally that is what the statute says, that there needs to be consent to the test or analysis. And let's just say that the statute does make a distinction when it talks about blood draws and consent to those specifically, and that we agree with you for a moment on the statutory literal words. Putting that aside, why is the remedy exclusion, given that, as you've conceded, there's no constitutional right here at issue? There's no violation of the Constitution. There's the failure of the officer who obtained a search warrant to then also call the driver and say, hey, do you consent to the test or analysis? Why do we have to suppress the information at this stage?
Thank you, Your Honor. The reason this court should suppress the BAC test results is because the legislature, in enacting this consent provision, created an exclusionary rule. It says that if the police fail to fulfill the requirements of the statute, the result is that the BAC test results are inadmissible. And the Commonwealth cites to no case that is like this, where the legislature has created an exclusionary rule and then the court just ignores that it's an exclusionary rule and decides to allow the evidence in any way. I would submit that.
Follow up on that. So you're right, the statute creates an exclusion, and it's that the evidence that the defendant failed or refused to consent to such test or analysis shall not be admissible against him. Right, so the failure or refusal to consent, right? Not the test or analysis itself, it's more limited. Or are you saying it's a failed test?
Your Honor, you're pointing to a second a second and additional exclusion. The exclusion that I'm talking about is covered by the first few sentences of 24(1)(e), where it says, in any prosecution for violation of paragraph A, evidence of defendant's BAC is shown by a test or analysis of his blood shall be admissible, provided, however, that if such test or analysis was made by or at the direction of police, it was with the consent of the defendant. And that word provided creates a necessary condition before the BAC test result is admissible. Its admissibility is conditioned on police getting his consent. I think that language makes that exclusionary rule. And then there's an additional exclusionary rule that has to do with a test refusal. And I would just add, Your Honors, that there's that additional language that says, not only do they need to get his consent, the results thereof were made available to him upon his request, and the defendant was afforded a reasonable opportunity to have another such test or analysis made by a person or physician selected by him. And the reason I draw your attention to that language is because if this court were to find a search warrant exception to defendant's consent, it would effectively repeal that opportunity for an independent test by the defendant, because police would do what they did in this case, which is get a search warrant for the defendant's blood after it's been drawn by a third party, test that blood, and never give the defendant this opportunity.
Ms. Grant, if I could interrupt you for a minute with the issue of the direction of the police. In Bohegan, I understand the majority view. I don't agree with it, but I certainly understand the majority view that the draw is at the direction of the police. But now, days later, pursuant to a search warrant issued by a judge, there's going to be an analysis of what was drawn. Isn't that just completely different than the situation in Bohegan, so that we can say, whatever one might think of the blood draw, I understand the majority position in Bohegan, that there's no way that this analysis now is being done at the direction of the police. If it were, there'd be a problem. It's being done, or there might be a problem, it's being done at the direction of a neutral and detached magistrate who granted a search warrant to do the analysis.
Your Honor, I would rely on, Bohegan's interpretation of what by or at the direction of police encompasses, which is the state actor. And I don't think that that changes whether the police are doing it later in the police crime lab. It is a state actor. It's the police crime lab that is testing or analyzing the blood. And that is what renders this inadmissible absent the defendant's consent.
Counsel, there's no question. Is there any question that the defendant in this case had noticed that they were not drawing, but getting a search warrant for the blood and doing their own analysis? And did the defendant have an opportunity to do his or his own testing?
I don't believe that the transcript covers that. I think, by implication, I don't think he was aware that the testimony below is simply that the police officer did not ask for his consent and got a search warrant and obtained the blood independently. So I think the fact that the police officer never even asked for consent indicates that the defendant had no idea this was happening behind the scenes. So, Your Honors, if there are no other questions, I would rest on my briefs for the rest of my arguments. And I would simply ask that this court find there is no search warrant exception, that because police did not obtain Mr. Moreau's consent, the BAC results that they obtained through their efforts would be inadmissible.
Can I just ask before you sign off, were you saying earlier that it would prevent the defendant from being able to do an independent test? How so? Because, yeah, how so?
Well, if the defendant, so we know that blood alcohol content diminishes over time. So the only useful test, the only meaningful test is going to be one that's done within a certain period of time. This is not in the record, but I'm not sure. I'm not sure how one preserves the blood in such a way that it could be used independently. There's no evidence from the Commonwealth that, somehow the police could have preserved the vials of blood that they had for the defendant to do an independent test. I'm not sure about that. But if the defendant is never given an opportunity by even being asked for his consent, I think that it can be assumed that that opportunity is lost because it is an ephemeral, test information.
Well, but that presupposes how much blood is actually drawn by the hospital at the time that it's drawn, right? Because I obviously know you're not going to get accurate results days later,
Right.
But if you use the blood that has been drawn at the time of the draw, then the defendant
I think we just simply don't have enough information about whether that's possible. And that in this context, if he wasn't given an opportunity at the time it was going to be done, that independent testing opportunity is lost.
All right, thank you.
Thank you.
Attorney Herron.
Good morning. May it please the court. My name is Donna Marie Herron, Assistant District Attorney representing the Commonwealth. The motion judge here properly denied the defendant's motion to suppress his blood test, where the defendant's blood was drawn by hospital personnel due to medical reason with no intervention or direction by the police, and thus involved no state action and did not violate any of the state.
Okay,
law
counsel,
provisions.
how do you get around the analysis piece of the statute, the word analysis?
I suggest, Your Honor, and I'm using the Aruda case as support, that once a third party state action, no state action, a third party intervenes and takes the blood, the statute is no longer operable. And in Aruda, the issue there was refusal evidence, and there the defendant refused to have his blood drawn to a medical personnel, and the medical personnel was allowed to testify. And this appeals court found that they've never interpreted section 23(1)(e) to apply to a third party private action. And I
But
would
in that
suggest,
case, counsel, were they drawing the blood with did the hospital or the third party test for alcohol?
no, that case was a refusal case, but I suggest the
refusal.
law that says, I'm sorry, Your Honor, the law that
No,
says
so that was a refusal, so they didn't test it.
no, I would also ask this court to look at Commonwealth v. McLaughlin, which I cite in my brief. There, the hospital did draw and test the blood, but the Commonwealth called a person from the lab to testify about the analysis of the blood and the conversion. Although the hospital gave the raw data to the state crime lab person, she testified to the conversion to blood alcohol level content. And that court, and again, it's an appeals court case, found there was no state action from the draw, and therefore it was proper for the testimony was properly admitted into evidence, and the blood alcohol evidence was properly admitted into evidence. And I would suggest that's the closest thing I could find, but the Commonwealth's position is once the blood is drawn by a third party with no direction or at the direction of the police, as in all the cases, as I cite, the Storella case, the McLaughlin case, the St. Hilaire, the Russo case, that the hospital could do whatever it wants with the blood. The hospital could have given the blood to the Commonwealth if they had so chosen. We did not need to get a search warrant, but at that point, once a third party has stepped in, that there's no more constitutional rights in that 24(e) and F, which again, as the judge found, there was also evidence, no evidence that the defendant refused. There's no refusal evidence entered into at the hearing. And I would also suggest.
Counsel, can I just interrupt you on that though?
Yes.
One of my other colleagues asked the question of Attorney Grant, the same thing. So this really isn't apples to apples with McLaughlin, because there's nothing in the record that suggests that tells us what the hospital did with the blood draw. Is there? I mean, did they do
No.
it? So
No, Your Honor.
okay, so if we had evidence that they did some kind of tox screen, and the hospital came back with an ETOH reading that the Commonwealth could then call someone to interpret, then we're talking McLaughlin. We're not talking that. We don't know what they did with it. So we don't even know if there's evidence that the state could come in and have somebody interpret. This is the state police taking what they took and analyzing it. So again, I go back to Justice Cipher's question. How do you get around the statute when the statute says that it has to either be the taking or the analysis? How do you get around the statute?
I get around it by saying that is referring to police action. And once the hospital draws the blood with no police direction or interaction, then the statute is no longer operable. As in all the cases cited in my brief, for when evidence is taken from a third party, the Commonwealth is allowed to do whatever it wants to that evidence, and there's no constitutional issues required. And I would suggest under the Aruba case and other cases that I would also extend to the statutory language, which I think is clear that, sorry, Your Honor.
Again, if I could just interrupt you on that. So at least as part of your statutory interpretation, the state action is only applicable to the taking.
Yes, to the drawing.
Not the analysis.
No, Your Honor, to the drawing of the blood or the force of I would suggest also for a breathalyzer test, forcing a defendant to breathe into a breathalyzer machine. It would apply to them. But when the state has no direction of requiring the blood draw, I think at that point, there's no state action, and the hospital could have given the blood to the Commonwealth without a search warrant if they had so chose, but they require for their own, I'm assuming, civil liability, require a search warrant. And that's when the Commonwealth went and got that. I would also just like to point out that this court in Bohegan ruled that it was under section 1F because the defendant refused to get his blood drawn. That's what this court found was could not be cured by search warrant, and therefore for safety reasons and under 1F found that the blood was involuntarily taken and was not admissible, even though we got the Commonwealth obtained a search warrant. They specifically found that E did not apply in that case. So I would and I would also suggest there's nothing in the record to support my sister's argument that the defendant does not have an opportunity to subsequently test the blood with his own physician or expert. There's nothing to support her argument that they do not have an opportunity to. I can tell the court I've done an evidentiary hearing where I know that they can, but it's not, I don't have anything in the record to support that. So I don't think one way or another it can be argued that the defendant does not have an opportunity to subsequently test the blood when files are taken by.
I'm not sure that's the issue that's being raised, though. I think the issue that's being raised is the lack of ability to have the independent medical analysis at the time it matters.
Well, I would suggest, Your Honor, that there's a lot of times where the Commonwealth, when they get stuff tested at a lab, invites the defense to have an expert there. I would also suggest there's nothing on the record to suggest that once the blood is drawn, the way it's kept diminishes the blood alcohol level in the tube that it's kept in. There's no evidence of that. If I'm testifying to something outside the record, I could tell you the cap they use does that, but there's no record support, so I cannot say that.
Those are all excellent points. I understand. I'm just not sure that's what the questions are getting at. The statute, one of the things that is available to the defendant is say that they just don't trust the breathalyzer because of many reasons that they might not. That they have a right to an independent medical test, the blood test, and that captures what the blood is at the time, independent. What you're saying is accurate, but it's the same source.
I guess I'm a little confused I'm sorry about this. I don't see a breathalyzer machine ever coming into play here because I can't imagine a situation where a medical personnel would have the defendant submit to a breathalyzer.
Well, it might not, but it is in the statute, and it rides along with the blood test. So even when you get to section F1, they're still talking about both the breathalyzer and the blood test, and they're talking about analysis also. So even though Bohegan only may have applied section E, I don't understand why it wouldn't also apply in section F. And I think I'm making Justice Gaziano bounce around in his seat.
Again, the Commonwealth's position is once the hospital draws the blood for medical purposes, there's no more state action involved, and therefore section E and F no longer apply since there's no more state action involved. And indeed, the hospital, if they so choose, could simply hand over the blood to the Commonwealth to do whatever it wants, as in other cases, as the Bullet case by Storella, or other cases in which the physical evidence is handed over to the Commonwealth and the Commonwealth is allowed because there's no state action to do whatever testing or subsequent analysis it feels to do.
Commonwealth wanted to conduct a genetic test of this individual to see if he was, I don't know, something. Your position is the Commonwealth would be able to do that so long as the hospital handed it over, regardless of their HIPAA violation.
Yes, because that would be, yes, Your Honor, because that would be a civil action, I guess, the defendant would have against the hospital if he so choose. But for criminal, the law is clear that once a third party, which has no direction or order by the state, is no state action involved. And therefore, the Commonwealth can do whatever it wants to the evidence that's handed over, such as the firearm. And
let's just say that we disagreed with you, that the Commonwealth couldn't suddenly start keeping a genetic bank of individuals that had been arrested for OUIs. Do we really need to adopt that extreme position in order to find your way here?
I don't think you have to, no, Your Honor.
So can I ask you then instead about the exclusionary rule? I'm sorry, Justice Faziano, did you want to?
No, it's fine.
I would suggest the exclusionary rule would not apply here because I think it's clear, and I would disagree with my sister that privacy is the clear emphasis of the statute. I think it's quite clear the emphasis of the statute, as First Justice Lowy said in his dissent, was to allow the Commonwealth to enhance the safety of our roads by deterring substance abuse driving, and to quote him, the collection and use of blood alcohol evidence of the statute is the principal engine of the statute. And I also suggest that safety concerns, as this court noted in Bohemian, is the main concern with the forced blood draw or forcing people to do stuff. And I would suggest that neither of that occurred here, and therefore the exclusionary rule should not apply because there was no safety concerns, which I think is the big impetus of the statute, on which this court found. And also because, as Justice Lowy stated in his dissent, the purpose of the statute is actually to allow the Commonwealth and give the Commonwealth tools to prosecute people for driving under the influence. And indeed, the implied consent would I would suggest go against my sister's argument that it's privacy concerns, where the purpose of that statute is by driving on the roads of the Commonwealth, you're implied to have consented to breathalyzer test unless you refuse, and if you refuse, then you have the 180-day loss of license, which I would suggest if this court adopts my sister's argument, then the Commonwealth could go back and suspend the defendant's license for 180 days then. I do want to draw the court's attention that there is legislative pending in the Thomas Clardy law that does address search warrants, and it specifically puts in that the police can get a blood draw through a search warrant, and that is currently pending in front of the legislators. The governor recently put that bill, presented that bill to be decided upon. It includes
Counsel, how does that help your argument? It seems to suggest a need for further legislation to clear this up.
Honestly, I think it addressed what this court held in Bohemian to overturn it, to say that you can get a search warrant to make an involuntary draw.
Right. So if that's the case, why does that not continue to apply? I mean, if they needed the statute to fix it, then don't they need it to fix this also?
I just don't think. I'm sorry. Did I interrupt somebody?
No, I'm interrupted. It's the blood draw, right?
Yes, it's the blood draw. And I also don't see the legislative purpose or this court specifically addressing that they thought that they prohibit the Commonwealth from legally obtaining blood that is drawn by a third party that is subsequently tested at a crime lab, that is what the statute was intended for. I don't believe that's a primary goal of the statute, and I don't believe that the legislative intent of the statute. And the defendant makes no effort to explain when submits to a test refers to blood drawn by hospital personnel that's subsequently tested at a crime lab. If there's no further questions, the Commonwealth will rest on its brief and ask this court to affirm the motion to suppress the order denying the motion to suppress the defendant's blood test